And so one of the things that I've been talking about is this flagrant violation of the Constitution and how the federal government has really been taking on a thug role, or these departments and so forth. I'm really putting myself out there because there's a lot of conservative talk show hosts that seem to be soft pedaling and looking at, well, most of these guys are still good. Well, a lot of them are probably still good, but I don't know about the most. I really don't know. I think that you can't say that because there is more evidence that proves that it probably goes much further than just the top few, 6 that have stepped aside, than anything else. But that being said, let me put my Federalist Papers cap on and source documents. And what I always say is, are the words in our founding documents that I am citing the words of deceit? Or are the words that we have been taught from our progressive education system, the progressive colleges and professors, lawyers, politicians, and bureaucrats, the words of deceit? You have to be the judge. And so in Federalist Paper number 46, which we've covered this before, but I want to bring it up, but ambitious encroachments of the federal government on the authority of the state governments would not excite the opposition of a single state or of a few states only. They would be signals of general alarm. Every government would espouse the common cause. A correspondence would be opened. Plans of resistance would be concerted. One spirit would animate and conduct the whole. In other words, that one spirit would get everybody moving and conduct the whole as far as dealing with the encroachment. That was Federalist Paper number 46, James Madison. And if you look at, and I've talked about it before, the Sedition Act, what did Madison do when they passed the Sedition Act? He took action. He didn't say, you know what, we're going to have to teach everybody about the Constitution. Well, people back then, they actually knew about the Constitution, but nobody understood it maybe to the same level as those who were really engaged in the debate. And so he took action by going to the state legislatures, because ultimately the state legislatures have the power over the Constitution. And when you get the collective state legislatures together and they're all saying, no, 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 you can't do that, then it is for real, folks. They can't do that, and they need to be stopping. But what happened when Jefferson and Madison went back to do those resolutions in Kentucky and Virginia, the other states wouldn't join them. And because of that, because the other states failed, what Madison and Jefferson then did was they nullified. That was their last resort regarding the law itself. And they mobilized a huge concerted effort over the next 2 years to basically unseat Adams and undo that law. And so even though they didn't technically undo it, it went away, and because they were in office, and it just went away. Unfortunately, what they should have done was they should have done a congressional resolution that states that there are boundaries and barriers within the Constitution that do not allow them to make laws that are contrary to the Constitution. Therefore, these 4 acts that were a part of the Sedition Act were unconstitutional, and therefore they are null and void, and made them go away. That would have been the proper thing for Congress to do, but they didn't. And so whether it be an act or a resolution, as I was pointed out today, because you can actually do a resolution where you don't need the president's signature. And so, because there's a good chance that Congress, in saving the government and saving our Constitution, will have to do resolutions instead of bills and acts that require the president's signature. Anywho, moving on. Yesterday I spoke about Hamilton and his phantom. And I'm not going to read it again, but he talked about this phantom argument that the federal government or the Supreme Court and the court system would be able to encroach upon the legislative branch. He says that's a phantom. There's just no way that can be done. And so he threw out this ludicrous argument about this. And I truly believe the phantom Hamilton spoke of was a ploy, because this is precisely where Madison, with his help of his close friend and protege, John Marshall, precisely where Hamilton and his protege Marshall against Madison, because if you understand, the first time they kind of stepped into undermining the Constitution was a case called Marbury v. Madison. And so this is where Marshall actually started taking those steps of self-aggrandizing itself with that case. And that particular case created property rights to jobs for federal government, and it started instituting precedents. And so this is, where Madison, I truly believe, failed, because that was an unconstitutional exercising of the court, and Jefferson should have been engaged in this. But at that point in time, they were going through the Louisiana Purchase. There were all sorts of other little distractions, and they failed. And I'll bet you anything, if I had Madison and Jefferson here and they looked at that and they go, yep, you know what, we really failed. We didn't think that would be as problematic as it is today. The other cases were Fletcher v. Peck in 1810, Sturgis v. Crowninshield in 1819, Dartmouth College v. Woodward, I should say, McCullough v. Maryland, and these were both in 1819, and Cohen's in Virginia in 1821, and Gibbons v. Ogden in 1824. All of these, in the ramblings and opinions of John Marshall, is where he made comment. And actually, the only one that was egregiously just wrong was Marbury v. Madison. Fletcher v. Peck and the rest of these, on the face, the verdict was correct, that the state of Maryland can't tax the federal government. The federal government has a right to be able to set up banks in the states and so forth, because it falls within the boundaries of the Constitution of needful buildings for them to do their job. Not necessarily creating big, huge fields for EPA and saving, jumping rodents and so forth. But anyway, if you look at all of these ramblings within these 7 cases that I've just mentioned here, these 7 cases created unconstitutional footings that established, or Marshall was basically establishing, that the federal government can be supreme in anything it deems necessary and proper. And so he was combining these 2 clauses within the Constitution that were literally confined to the enumerated powers. The clauses within the Constitution in granting the General Welfare Clause of General Welfare and Defense, the Commerce Clause granting the federal government oversight over commerce between the states when there are disputes, and it's the same thing with the Necessary and Proper, the Supremacy Clause. These clauses were designed specifically towards the enumerated powers. They were not, and Madison clarifies this in 1817. He clearly states that these are not portals, and I'm paraphrasing because he doesn't use the word portals, but these clauses were not portals for the federal government to be able to grab any new power. And everybody today believes that the Supremacy Clause means that the federal government can do anything and everything, and that's absolutely wrong. That goes against what Madison was saying and what the whole ratification debates were talking about. And I believe this phantom in this Federalist paper that I read yesterday, that was a red herring, and I believe it was a ruse by Hamilton in trying to undermine, and he knew this, and he basically was just kind of protecting this little facet that he would be able to start rising up tyranny from the bench. Now, I think John Marshall, being a pretty decent man, didn't realize what he was doing. But even though it's noble, and what he may have thought was a noble thing to do, I'm here to tell you that the methods and what he did was nefarious, because he knew, And how did I know he knew? Because John Marshall was at the Virginia ratification debates and he even spoke. So he heard what was being said. He heard the limitations on the federal government, that they weren't supreme in all things. They were only supreme in those things delegated. And Nichols made that very clear. And he, being a Federalist, didn't care about whatever the other Federalists said. What he felt and what he thought was what he was going to enforce. And if it's not within the confines of the contract and not within the confines of the discussions in defining that contract, it is not contractually, legally binding. So everything he was doing was violating that contract. He was violating the Constitution and how the Federalists defined, and the delegates from the Constitutional Convention defined that contract. And hopefully that is really clear here, because I don't know if I could articulate this as well again. I think probably I might be able to.